Hello everyone, this is Ming Yao from Beijing Weijixue Law Firm. I have 15 years of experience in practicing IP law in China, focusing on trademark and unfair competition cases. I'm very happy to be here today to share with you one of the cases I have represented. In this case, the right holder's product design was more than 4 decades old. Chinese patent law couldn't do anything about it, but this is not the dead end. Here is another option. In this video, I'll introduce you how to protect your product design according to Chinese unfair competition law. Now let's get started. First, let's take a look at the right holder's product and the accused product. On this side is the right holder's product. It's Royal Oak watch, and you can see that the right holder's trademarks AP and Audimus Piguet are indicated on the bezel. And on this side is accused watch, which is almost the same as the right holder's watch, Royal Oak watch. And you can see here that the accused watch has its own trademark. Chinese unfair competition law provides protection for product package and decoration, which is of certain influence. Here you may have a question. You showed us a watch. How is that related to product package or decoration? Let me explain more. The product design could be deemed as product decoration when the design plays a role in identifying the source of the goods. Now I'm going to move on to discuss the necessary conditions to protect your product design according to the Chinese unfair competition law. 4 conditions shall be met. Now let's see the first condition. The product using the design must be well known in the market. Here it refers to Chinese market. This is a precondition that the product design to be protected by Chinese unfair competition law. In other words, a product that is not well known in the market is not protected by the Chinese unfair competition law. In this case, we submitted audit reports of the right holder's subsidiary, sales invoices, advertising contracts, newspapers and magazines, online reports, and the Fortune 500 ranking of the world brands to prove that the right holder's Royal Oak watch is well known in the Chinese market. Now let's move to the second condition. The design shall play a role in identifying the source of the goods. What does this mean? The essential requirement of this condition is that the product design plays a role like a trademark, indicating the producer or provider. Since the product design usually is an integral part of the product itself, consumers generally do not use it to identify the producer or provider. This condition is most difficult in practice. How did we prove this point? In our case, 2 steps are involved. In the first step, we defined the main features of the design claimed for protection and proved such design is distinctive from common designs. In our case, the octagonal bezel featuring 8 hexagonal screw heads is distinctive from common bezel designs like circular, square, rectangle, oval, etc. Moreover, the 8 hexagonal screw heads are very unconventional. In the second step, we proved that the relevant public has established a stable connection between the Royal Oak watch and the right holder, Audimus Piguet. We adduced proof in 3 aspects for the second step. Number 1, the design of octagonal bezel featuring 8 hexagonal screw heads was launched in 1972. The main design features have never been changed over 4 decades. Such design has become the iconic design of the Royal Oak watch. Number 2, a large number of newspapers and magazines have reported and commented on the uniqueness of the Royal Oak design, which proved that the design features of Royal Oak are highly recognizable among the relevant public. It was enough for the relevant public to connect the design with the provider. Number 3. We reviewed the consumer comments of the accused watch. A number of the comments were, it was a sheer copy of Royal Oak. That is to say, when the design octagonal bezel featuring 8 hexagonal screw heads is separated from the Royal Oak watch and connected with another trademark, consumers can still identify it as a Royal Oak. At this point, we can fairly say the second condition has been met. Now let's move to the third condition. The design is neither determined by the nature of the product itself, nor is it necessary to achieve a certain technical effect or make the product of substantial value. When the second condition is met, it is easier to meet this condition. As long as the product design is unique and not functional, we can say this condition has been met. Now we come to the fourth and last condition. The use of the design by others is likely to lead to misunderstanding and confusion among the relevant public. The confusion and misunderstanding here does not mean confusion and misunderstanding that occurred actually. Instead, it only requires the possibility of a confusion and misunderstanding. Therefore, when the above 3 conditions have been met, and the accused design is closely similar to the product design claimed for protection, we could draw a conclusion that the use of design by others is likely to lead to confusion or misunderstanding among the relevant public. That's all for today's topic. Hopefully now you have some ideas on the protection of product design when it is not patented or the design patent is expired. If you have any questions about IP in China, we are happy to assist you. Thank you for your listening. This is Min Yao. See you next time.